Good evening. My name is Eric Ip, and I'm the author of this book, as well as the co-director of the HKU Center for Medical Ethics and Law. And this is my first book published after taking on this position. It's wonderful to see you all here tonight, and it's my great privilege to share my thoughts in relation to this book with all of you. And thank you very much. Tonight, I'm privileged to have Professor Edward Lui, Assistant Professor and CMEL's, the Center for Medical Ethics and Law's newest research fellow, to be our discussant. I hope he will talk about my book in a charitable manner. So let's make this an incredible event. I'm quite proud to say that this monograph, the Law and Regulation of Public Health in Hong Kong, Global Perspectives on Hong Kong, is the first ever book-length study of public health law in the Hong Kong Special Administrative Region. To my best knowledge, it's also the first book in English on public health law in any Asian jurisdiction. Most books on this subject just focus on the public health law of the United States. For your information, there is only one book, one only, on contemporary British public health law. So some of you might be thinking, aren't there already several books about Hong Kong medical and health law out there? Medical and healthcare law out there? You are absolutely correct. But here's the thing, public health law is a different game. Just like how public health and clinical medicine are not the same. In fact, in our LKS Faculty of Medicine, the School of Public Health and the School of Clinical Medicine are different departments. They're not the same. So public health law is also a species of a different kind compared to medical and healthcare law. The main focus of public health law is about the limits that governments have when it comes to protecting the health of the people at a population level. It's about the constitutional and legal boundaries that public health authorities must navigate. Medical lawyers, by contrast, are more interested in things like making sure individuals give their consent for medical procedures at a patient level, at an individual level. So the difference is between the focus. Public health law focuses at the population level, while medical law, traditionally understood, focuses at the individual level. Now, of course, medical law can also be understood expansively, as in our center. Medical law also encompasses public health law, just as the Faculty of Medicine also encompasses the School of Public Health. Now, what about public health lawyers and ethicists? If they are not concerned or primarily concerned with consent for medical procedures, they are more concerned with this tricky triad of governments, populations, and individuals. So you can imagine a triangle with governments, populations, and individuals. Yes, individuals are also part of the equation, but they are not the only part, or they are not the entire equation itself. So public health lawyers and ethicists are concerned with the conflicting interests that come with this triad or triadic relationship. In the 20th century, all those incredible achievements in public health were made possible by law, if you think about that. I'm talking about things like sanitation, decent housing, clean water supply, mass immunization, and road safety. These are driving forces behind the amazing progress we've seen in health and disease reduction since the 19th century. Criminal laws can really make a difference when it comes to encouraging behaviors that promote public health. Just look at how injuries among road users have been reduced because of tough road safety laws. But there's also a dark side to all this legal power. Sometimes legislation that's supposed to promote public health is really just serving private interests, can even lead to inequality, discrimination, and stigmatization. And worst of all, it can actually facilitate the spread of disease, hurting the well-being of whole populations. So we've got to be careful. With regard to these laws, these sort of laws, you can think of sanitation laws in the late 19th and early 20th century Hong Kong, which dealt with the third plague pandemic and which segregated the local Chinese population from the Europeans, etc. So we need to make sure that the laws we pass truly serve the public interest and don't do more harm than good. When it comes to public health decisions, we definitely need the guidance of epidemiologists, microbiologists, and physicians. They bring their expertise to the table, and that's important. But here's the thing, relying exclusively on them is just not enough. In fact, it's woefully inadequate. You see, an epidemiologist can tell us about the potential impact of delaying a lockdown for a week, estimating the excess COVID-19 deaths that could occur. But an economist who knows nothing about epidemiology can also provide valuable insights as well. They can estimate the economic loss that could be avoided with a delay, which could actually help reduce the death toll perhaps more effectively than just relying on lockdowns. Scientific expertise is invaluable, but they can't answer all the crucial questions that governments face during a public health crisis and beyond, such as the proper relationship between citizens and the state, trade-offs and policy making, and we can't rely solely on public health experts with regard to these questions. Please don't get me wrong. Epidemiology and microbiology are absolutely crucial in our fight against any epidemic. We can't deny that. But we should question slogans like the UK's follow the science if it means blindly accepting the opinions of biomedical scientists on matters that go beyond their expertise. Take as an example, the appropriate balance between health and other dimensions of human well-being, such as familial love, friendship, and economic stability. There's more to consider. We need to think about the preservation of the rule of law and constitutional rights and liberties. The more a society values the rule of law, the more it safeguards the intrinsic dignity of human beings. It establishes obligations and incentives for governments and other powerful actors to invest in the value of none other than humanity itself, which of course includes, but is not limited to, a commitment to public health. It's not just about physical health alone. It's about upholding the rule of law and protecting our fundamental rights, which I think also include the right to mental health. And there's empirical evidence that supports this. As cited in my book, there are studies that have shown that the rule of law is associated with health outcomes independent of a country's economic development, health expenditures political freedoms, economic inequality, or the status of women. The rule of law is just as essential to human well-being as public health. In fact, the rule of law can be said to be a vital determinant of population health. So the rule of law is a social determinant of population health, including population mental health, which is a topic that I wish to explore in my next book. We need to consider a multi-dimensional approach that values both public health and the rule of law to truly promote the well-being of our society and its members. All over the world, there are judges and lawyers who concede that they don't know much about the biomedical and public health sciences. That's understandable, given doctrines of judicial deference and the margin of appreciation for public experts, including public health experts, of course. But what they've overlooked is that those biomedical and public health scientists do not necessarily know much about constitutional, administrative, and human rights law either. So it goes both ways. As argued in my book, I believe that jurists should have their fair share of authority to figure out the legal boundaries of public health interventions, even during public health emergencies. Only the law can protect the freedom of scientists to seek truth, as well as the freedom of ordinary individuals to live by their own principles. In other words, those who make and interpret public health laws have a huge responsibility. They need to understand how science and law work together and how it all affects our society, institutions, and values. One of the big points in my book is that public health has a legal side, just as much as it has an epidemiological side. An optimal public health intervention has to achieve its goals while respecting our constitutional principles and rights. It doesn't matter how efficient or effective a proposed intervention might be, if it goes against the rule of law, constitutional law, or statutes currently in force. As the Hong Kong High Court has said in Kwok Chek Kin and Secretary for Health, there's a right way and a wrong way to get the desired public health result. And the role of the law is to ensure that public health decision makers walk the right path in achieving their goals. We can't just do whatever we want, no matter how good the outcome sounds. And there's no good reason to think that lawyers should just step aside and let public health experts make all the decisions, even on their behalf. So let's encourage our judges to exercise their powers to navigate the legal aspects of public health. We need to find the right way, follow the law, and respect our constitutional principles. That's how we will get the best outcomes for everyone, and this is the gist of my book. Prominent British astrophysicist Martin Rees, or Lord Rees, recently advised that we should recognize that scientists follow the same traditional style of reasoning as lawyers. Following the science is not a guaranteed path to safety if we only understand science as empirical science. But there's more to it than that. We need to consider ethics and juridical science as well. Empirical truths are one thing, but normative truths are another. Human rights, like the rights to life and health, cannot be observed in the empirical world. The principles of justice, social justice, can't be reduced into molecules or atoms. They exist in social experience and are worthy of academic inquiry, even though no one has ever seen a human right as a tangible thing. Yet we can't deny their existence and the normative truths that they protect or represent. The laws of nature simply describe what will happen. The human laws, including public health laws, prescribe what we should and should not do. And that's where my book comes in. The main purpose of the book is to articulate the framework principles that define the study and practice of public health law and provide reliable guidance to public health decision makers and judges and lawyers, as well as the general public, on how to promote population health while upholding the rule of law. You see, public health law has to strike a balance between promoting the health of the community through education, intervention, and regulation and surveillance, while infringing on the constitutional principles of freedom and privacy as little as possible. What serves the community may not serve its individual members equally, not only because individual physiology and health are unique, but also because certain policies may impose burdensome and unreasonable duties on individuals who want to plan families and plan their own family lives and individual lives and exercise their freedoms in their daily activities, which, if we think deeper, constitute the core of human dignity. That is the ability to plan our own lives ahead. The reason for choosing Hong Kong as a central case study for this book, which is of relevance to all public health lawyers across the world, is plain and simple. Hong Kong is a fascinating case for both law and public health. When the British first established Hong Kong as an outpost in the Far East, it was one of the most unhealthy and dangerous places on earth. Cholera, smallpox, malaria, and measles were rampant. And the British Vice Consul even wrote in 1849 that it was the most unhealthy spot in China, sparing no one. And yet, in just a century and a half, Hong Kong has become a cosmopolitan city with some of the best public health indicators in the world. Its healthcare system is one of the most efficient, and its average life expectancy ranked top in the world in 2017. Women had an average life expectancy of 87.66 years old, with men at 81.7 years. This was achieved, however, by spending only 6.2% of our GDP on healthcare, compared to 17.1% in the United States. And let me tell you, healthcare is nearly free for residents in Hong Kong. Over 95% of eligible children are immunized for free against 11 communicable diseases under the Childhood Immunization Program. And children from families entitled to Social Security assistance can receive free flu vaccinations as well. And Hong Kong's public health experience has had a significant impact on global health. Margaret Cheng, the former Director of Health of Hong Kong, served as Director General of the World Health Organization for a decade between 2007 and 2017. She undoubtedly brought the experiences of Hong Kong's public health system to global health governance. From being one of the unhealthiest places on the planet to having a world-class public healthcare system and top public health indicators, Hong Kong's transformation is truly remarkable. This is the last part of my talk tonight. It outlines the essential ingredients of this book, which follows a generalizable and systematic framework for analyzing public health law, which can be applied anywhere in any jurisdiction, and so may be useful for scholars in the field from other countries and territories. It covers all branches of public health law comprehensively. Now, chapters 1 and 2 go deep into the conceptual and historical foundations of public health law. We're talking about Hong Kong and the rest of the world. So in chapter 2, I outlined the history of public health law from time immemorial through the Old Testament, the Bible, to ancient Greece and ancient Rome, plus ancient China, and then all the way to the Middle Ages, the quarantine policies against the Black Death, and the rapid development of public health laws in England since the 16th to 17th centuries. It's important to understand where it all comes from. Undoubtedly, the public health law of Hong Kong was a brainchild of English public health law, as we incorporated numerous elements from public health law from that jurisdiction. Then we got chapters 3 and 4. They focus on the legal infrastructure of the public health system. We are talking about constitutional duties of all the actors in the system. So not just about the hospital authority, but also about the chief executive, the legislative council, the judiciary, and the public health bureaucracy, understood broadly as encompassing the health bureau, the ecology and environment bureau, and the labor bureau, which is in charge of occupational health and safety. And let's not forget about chapters 5 and 6, which dive into how the law allows the government to intervene when it comes to containing communicable diseases. But at the same time, the law puts constraints on those interventions. Now, chapters 7 and 8 review the law that enables public health interventions for alcohol, tobacco, food, and drugs. And although there is a very mature legal regime regulating tobacco, thanks to the work of the HKU School of Public Health, among other actors, the law regulating alcohol and obesity is much less developed, and in fact, much of the law, as I understood, consists of soft law. So in this study, I also incorporated soft law developed by the public authorities as part of my analysis. To omit them, to omit guidance issued by the Labor Department on how to comply with occupational safe health legislation, to ignore the government's climate change plan, etc., would be a serious omission that I would want to avoid. Chapter 9 is about the factors that affect public health in our built and natural environments. And so occupational health and environmental health would both be covered, or were both covered in this chapter. And finally, chapter 10 wraps it up all. It summarizes the fundamental principles of public health law that I think are transcendental, that applies across the world, not just Hong Kong, although its elements can be deduced from the Hong Kong Basic Law and the common law as well. It challenges readers to think about what public law should be, not just what public health law is, what public health law should be. So we've reached the end of my brief introduction to this book. And it's time for me to step aside and let Edward share his views on the book. Thank you very much. Thank you.
Thank you a lot for this presentation and also for inviting me to discuss this in the first place. Can I just begin by saying that this book, I think, is really impressive just from how detailed the research was. One simply needs to just look at the footnotes to see how much reading has been into it, and also the very detailed analysis of the various bureaucratic structures in the institutions that run the public health system, and also in reviewing the literature and also the case law in these areas. I personally, I haven't really seen this done. So like you said, I haven't seen this being done in a Hong Kong context in this really encompassing approach. So I think this of itself certainly deserves a lot of merit, just to start with that. I, in particular, also really like how there is this framework being laid down. So like you said, there are some areas that can be further developed, like mental health, for instance. But I think certainly the framework here already laid down the foundations for a lot of work along these lines. So I must begin with that. For my discussion, I would just like to bring up 3 points that may be of interest to those who are reading the book, who will read a book, or just who are interested in public health law in general. So the first point relates to Eric's theme that public health law is an area of public law. Now, that actually is a very interesting thing. And in fact, for me, I first started thinking it as a sub-branch of medical law. It probably still is, but it has a very different angle here where you have the subject matter, where it is normally, I would say, seen as a subcategory of medical law, but now we subject it to the values in public law. So we say this is an area which is not only a healthcare sort of area, but also is a public law sort of area subject to public law values. Now that in itself, I think, is actually really interesting because of how the different legal areas may stress different and possibly conflicting values. So like you said, for instance, I would take that medical law sees paternalism as a bane, sees it as something that is objectionable. But in fact, for instance, if one looks at, say, administrative law, a very strong emphasis, in fact, is precisely expertise to the bureaucratic structures, that if there is a bureaucratic structures that is very informed, that very well considered, in fact, in many cases, the courts will refrain from intervening and in fact will commend the use of expertise. So to put it in other words, it commends paternalism in a sense. So you can already see if I subject the same area to both public law values and medical law values, we can have very interesting interactions and conflicts. So that's the first theme I like to bring up from the book. The second theme comes from that. So now we've known that public health law is about public law values. Now, we can do one step further and ask, well, what then are those public law values? So for instance, there are some names and concepts which are pretty uncontroversial. Like for instance, many people would agree that at the very least, one of those values would be, say, the rule of law. But it actually invites us to ask a further question. What then is the rule of law? Because think about this, public law is a really broad family. For instance, it includes administrative law, constitutional law, human rights law. The question, and in fact, I think it does invite us to investigate, can these sub-branches of public law have their own various and distinct internal logic, have their own distinct rules and views of things that bring a different perspective on public health law? Now, just to give a really short technical example of this, Eric just brought up the example of soft law, of government policies. And in fact, different areas of law in public law deal with that differently. So for instance, proportionality-based analysis would look at it, for instance, through the lens of prescribed by law requirements. So looking at, is it certain enough? And if it's not certain enough, cases like, for instance, Gillen, Purdy tell us that the court may intervene on that basis. Administrative law, however, doesn't look at it in this way and introduces various different controls on soft law. So for instance, the idea that according to Lumber, if you depart from a government policy, you must have justification for it. So they are not necessarily inconsistent, but they offer distinct apparatus to see how public law interacts with public health law. So that in itself, I think too, is a very interesting avenue for further investigation. So, so going also about this question of what do the public law values say? Just now, one possibility is that different sub-branches of public law may think differently about what do the public law values say, what are the public law values are we talking about in question? Another aspect to look at this question is to see what are the methodologies in which we use to ascertain what are the public law values at play. Now, one way to do that may be through a very theoretical abstract investigation. So for instance, one may begin with very foundational political and legal philosophy and infer that public law values must be theoretically prescribing this or that. I think that's one possible approach. Another approach, which is not necessarily inconsistent with this, will be, I suggest, institutional. So in fact, instead of prescribing a priori, these are what the public law values say about public health care, maybe another approach is to invite different institutions to collaborate and have a dialogue for what that means. So for instance, Eric's book has, I think, a pretty good example of this. So he surveyed a bunch of cases during the COVID pandemic where the cases were brought to the courts. And in fact, you can say as the pandemic evolved and the circumstances changed, the court's remarks in those cases has also changed. The courts have given different impressions and comments on how the pandemic is being responded to. And in fact, one may see this as some sort of institutional dialogue where one may say it's not that the courts have the uniquely correct answer or necessarily the preferable answer of what public law values say, but it is in fact different institutions bring in their own views and through time, experience, and practice, having a very detailed recent deliberation on what precisely those values prescribe in particular factual circumstances. And you may disagree with that. You may entirely disagree with that, but that's all right. I'm here just to invite further thoughts and discussions. So we just talked about the introduction of public law values into the area. We then talked about what the public law values are and how do they run. Let me go to a third point, which is distinct but related to the points just now. Let us say we all accept that public health measures must be subject to public law values. Let's further, for instance, say we have this impeccable way of ascertaining what precisely those public law values we're talking about. Then I think there is in fact a third question. Who enforces those public law values? I think a very intuitive answer would be to say that surely it will be the courts that enforce them. And if the public law values are violated, surely it must be for the courts to come in and then subject the decisions to the public law values. I think it would be a really popular answer. I think at the very least, there's room for reasonable debate about this point. So for instance, is it possible to say other institutions within the structure, say, for instance, even within the bureaucracy, there are different organizations with different sort of expertise. Could it be that those institutions themselves could be in their own right enforcers and appliers of the public law values? This is just one example, but I'm simply trying to point out that, in fact, the role may not rest exclusively in the courts, even if we have this perfect account of the public law values. So that I think there may be a further question about how do we enforce those public law values. And if we have to pursue this line further, then I think I'm afraid I'll be dragging everyone into an investigation of constitutional theory, which I'm sure many people here are not interested in. So I'm just simply pointing these points out. I think this book is, just in its own right, is really detailed, and I think lays down so many foundations for future investigations about public health law in Hong Kong. And this in itself is very commendable, I must say. I think also it provokes many different questions that certainly one can certainly think about and potentially to contribute about this in writing about public health law. So these are just the very little comments I have about this, and thank you once more for listening.
Thank you so much, Edward, for your truly charitable comments. Thank you so much, and you can all get a discount by using the QR code on the poster of today's book talk. And I'll stay behind for a few more minutes just in case you wish to discuss anything with me. So thank you very much for attending this event. It's again my great privilege to have Edward as discussant. Thank you very much, and see you in the near future, hopefully. And enjoy your holidays.